My name is Patrick Fife. I'm the general counsel here at LIBOR. And welcome to today's webinar. And I'm going to be providing you with an update to the upcoming New York Property Condition Disclosure Act amendment that goes into effect next week, March 20th. If you have any questions as I'm going through, we do have the Q&A open. I'll leave some time at the end, about 10 or 15 minutes, to take questions through the Q&A. But I'm going to go through just about everything possible. Any question I think that you could ask, I'm hoping to cover. So hopefully that will limit the questions. But if you have them, try to save them to the end, and we will go through them as best we can. We have about 800 or 900 people registered for the webinar today. So if we can't get to every question, I apologize, but we will certainly try to do our best. So with that, I'm going to get started. And I'm going to talk just kind of basic about, an overview of what I'm going to cover. And that is going to be the amendment to the Property Condition Disclosure Act. The amendment, as I said, goes into effect March 20th. And there's really been two changes to the Property Condition Disclosure Act. The first is that the statement itself, the Property Condition Disclosure Statement, is changing. Some new questions are being added to it regarding flooding history for a property. And the second change is the elimination of the $500 opt-out credit that sellers have been able to take advantage of, as opposed to actually providing the buyer with a property condition disclosure statement. So I think to a lot of people, and obviously we have a lot of people here, so it must sound like a big deal. Is it? I think that's a question. I actually think it's going to be a bigger deal for the real estate attorneys. And I'm happy to say I don't think it's going to be such a big deal for real estate brokers, real estate agents. And I'm going to explain that to you today. The best thing as far as it goes for real estate licensees is your obligations haven't changed. Your obligations under the law remain the same as they are today. So, and the reality is it's not going to change things that much for you. I will explain the changes, but they're really not going to be that significant for our industry's perspective. You may get some more questions. I think that's going to probably happen, but as I'm going to explain, most of those questions are probably things that you cannot or should not answer, and I will explain why. So before I get into the amendment, I'm going to just give an overview of the Property Condition Disclosure Act. What is it? Because I think there may be some of you that aren't familiar with it. The law itself went into effect in 2002, so it's been with us for quite a while. And the law requires sellers of certain residential real property, and I'll explain the types of properties that require the statement, but certain properties, the sellers have to provide a property condition disclosure statement to prospective purchasers prior to the signing of a contract that lets them know about the defects relating to the property or the history of defects relating to the property. The current law allows sellers to opt out of providing the statement to the buyer by giving a $500 credit to the buyer at closing. When the law went into effect here on Long Island, New York, I think most real estate attorneys gave the advice to sellers that, hey, it's not worth providing this statement. You're putting something in writing concerning the property. It may lead to potential liability down the road. So their advice was just provide the credit to the buyer. And I think the practice that's developed here on Long Island and in New York City is pretty much most sellers did that. I practiced real estate before I came here to LIBOR and real estate law, and I really can't remember a transaction that I was involved with that the seller didn't give the buyer the $500 credit at closing. So, that's why that change, I think, is so significant here, because it is a practice that everybody, for the most part, engaged in. And now it's going to be a practice that sellers cannot take advantage of. So what are the changes again? They go into effect March 20th. All right. The property condition disclosure statement will have some new questions on it related to a property's flood history. The sellers, as I said, they can no longer, on March 20th, sellers can no longer opt out by giving the buyer a $500 credit at closing. So the result of that means that the property condition disclosure statement's going to be required on every residential real property transaction in New York. And you'll see I put those words in quotes. Residential real property is defined by the law. And this has not changed. This is the current law. This is going to be the amendment. A seller of residential real property must provide and deliver a completed property condition disclosure statement to a buyer before the buyer signs a contract of sale. What does residential real property mean? It's property improved by a 1 to 4 family dwelling. It does not include vacant land, condos, or co-ops. So that's the current law. That's not changing. So co-ops, condos, sellers of vacant land do not need to provide a property condition disclosure statement and will not have to provide one after March 20th. There are other exemptions to the property condition disclosure statement. These have not changed. These are in the current law. They're not changing. There's 14 other exemptions, everything from bank-owned properties, court-ordered sales, fiduciary sales, meaning an estate, a trust, new construction. However, and I have the steps up to the courthouse here, that's for the attorneys to explain. You should not be advising sellers whether a transfer qualifies for an exemption. Sellers should be speaking to their attorney to determine if an exemption applies. So where can you get the new form? It's a new 7-page, 56-question form. It can be downloaded on the Department of State's website. We're going to put the link. It'll be available to you. I'm going to reference some materials at the end where you can get it, but it's on the Department of State's website. It's also available on LIBOR's document on demand page. It will be available on Instinet through OneKey. So you will be able to get it. The form's there now, like I said, but don't start using the new form until March 20th. If you take a listing today or through March 19th, you should be providing the current property condition disclosure statement to the seller. I encourage all of you to read the form if you have not. There's a lot of good information in there. Really the basics of what the property condition disclosure statement is. I'm going to actually quote from portions of it. So I encourage you to read it so you have a better understanding of exactly what it is and what the sellers are signing. So what are your obligations as a real estate licensee? What do you have to do regarding the property condition disclosure statement? The good news is your obligations, as I said at the beginning, they have not changed. They are the same as they were before. So if you're the listing agent, you have a duty to provide the property condition disclosure statement to the seller and timely inform them that a signed property condition disclosure statement has to be delivered to the buyer or the buyer's agent prior to the signing of a binding contract of sale. And you also have to let them know that the property condition disclosure statement containing both the seller and the buyer's signature has to be attached to the contract. That's your obligation as to the seller. As to a buyer, the buyer's agent or seller's agent dealing with a prospect as a customer has to let the buyer know before a contract of sale, before the signing of a contract of sale, what the buyer's rights and obligations are under the law, which is that the buyer has the opportunity to review and has to sign the property condition disclosure statement, and it has to be attached to the contract of sale. That is it. That is your obligation under the law. And what happens if you fulfill that obligation? Really good news. This is right from the law. The law says the agent shall have no further duties under this article and shall not be liable to any party for a violation of this article. So if you do what you're supposed to do, and that's that limited providing the form to the seller, letting the seller know what their obligations are under the law, you fulfill your duty and you can have no further liability under the law. So that begs the question, why would you really want to do anything more? And we're going to talk about that. You're protected if you fulfill your obligations. Doing anything more can open you up to potential liability. So there really are only two differences on March 20th when it comes to the way we operate. First thing, on March 20th and beyond, you will provide sellers the new property condition disclosure form. That's the new one that's available for download. The second thing, hang on one second. I'm stuck here. There we go. You can no longer advise sellers that they have the option of giving that $500 credit to a buyer at closing. Right now, the disclosure that we have in the One Key exclusive right to sell agreement mentions to sellers that they have the option of providing buyers a $500 credit at closing in lieu of providing the statement. We're getting rid of that. There's no more mention of a $500 credit. That's it. Those are really the only two changes when it comes to informing sellers of what their obligations are under the law. All right. So what does that mean for your listings? Let's say you have a listing that's under contract as of March 20th. It has not closed, but it's under contract. For all of your listings where the contract of sales already signed, your clients, it's signed by March 20th, the property condition disclosure amendment, it's not applicable. The seller at that point does not have to provide the property condition disclosure statement, and they can still avail themselves of that $500 credit. They are already in contract. Remember, the property condition disclosure statement needs to be provided prior to execution of the contract. So if the contract's already been executed prior to March 20th, those sellers are fine. They don't have to provide a property condition disclosure statement, and they can instead provide that $500 credit at closing. What about your active listings that aren't under contract as of March 20th? So let's say you take a listing today, and March 20th hits and that listing is still active. It's not under contract. What are you going to do? In that instance, you're going to want to provide the seller with the new property condition disclosure form, the updated one, and tell them that they have to sign it and provide it to a buyer prior to contract of sale, and that they can no longer avail themselves of that $500 credit in lieu of doing so. That's it. There's really nothing more that you have to do. So going forward, what should you do, in terms of providing the property condition disclosure statement to the seller? Let's say March 20th and beyond, what should the normal process be? When should you provide the statement to the seller? It's really easy. You should provide it to the seller at the time you take the listing. So when the listing agreement's signed, you're going to provide the property condition disclosure statement, the blank form, to the seller. You can provide it to them any way. It can be provided electronically. It can be provided by hard copy. Best practices are, you're going to want to document that you gave the seller the property condition disclosure statement and that you inform them of their rights under the law. You also should strongly recommend that sellers and buyers too, they should discuss ramifications, questions about the property condition disclosure statement with their attorneys. So how are you going to document that you did this? I said, you want to provide the seller with the property condition disclosure statement, and you want to notify them of their obligations under the law. How are you going to do that? Well, you want to get some kind of written acknowledgement from the seller that you've done that. You should have been doing this already. Even though, sellers could opt out of providing the form, you still, right now, today, and since 2002, you always had an obligation to provide the form to the seller and let them know what their obligations are. If you look at the One Key exclusive right to sell agreement in paragraph 17, it actually has a provision in there about the property condition disclosure statement, letting the seller know what their obligations are. That has been updated and it's available right now, but you shouldn't start using it until March 20th, an updated version that removes any reference to the $500 credit and let sellers know that they should speak to their attorney if they have any questions. We also, on Documents on Demand, have a property condition buyer's rights and seller's obligations form. It's a form that a seller or a buyer can sign off as an acknowledgement that you explained to them what their rights and obligations were under the law. Again, these documents are already available. They're on LIBOR's Documents on Demand page. They'll be on Instinet. But don't use any of the updated forms until March 20th. They're actually labeled "Do not use before March 20th." Again, it's for now, you should still use what you've been using. Use the current one key exclusive right to sell agreement. Use the current obligations form, acknowledgement form. Use the current property condition disclosure statement. It's March 20th where you're going to start using the updated versions of those forms. So I mentioned the one key exclusive right to sell agreement in paragraph 17. That is going to be updated this is the version that's effective on March 20th. This really covers it for you. As long as you provide this disclosure to a seller when you take the listing and you give them the property condition disclosure statement, you've met your obligation with the seller. So what does paragraph 17 say? And I know there's a lot of words here, but I'm going to read it just because this is it. This, in essence, is what you have to let a seller know. And once you've done that, you've fulfilled your obligation under the law. So it's right there in the listing agreement, and you have the seller sign the listing agreement as an acknowledgement. So it says, as the owner of residential real property, owner must complete and sign a property condition disclosure statement as required by Real Property Law Section 462(2), and cause it or a copy thereof to be delivered to a buyer or buyer's agent prior to the signing by the buyer of a binding contract of sale. A copy of the property condition disclosure statement containing the signatures of both the buyer and the owner must be attached to the real estate purchase contract. If owner acquires knowledge which renders materially inaccurate a property condition disclosure statement previously provided, owner must deliver a revised property condition disclosure statement to the buyer as soon as practicable. In no event, however, will owner be required to provide a revised property condition disclosure statement after transfer of title from owner to the buyer or after the buyer has commenced occupancy of the property. Owner should seek the advice of their attorney regarding the filling out and exchange of the property condition disclosure statement or any questions as to owner's obligations under the law. So if you provide this and it's in the one key exclusive right to sell agreement and have the seller sign off and you provide them that form, again, you have fulfilled your obligation at that point. All right, so here's some of the questions that I've been asked that have come up in some other presentations I've given. So should I help the seller fill out the property condition disclosure statement? And the answer is clear. No, the property condition disclosure statement is for the seller to fill out. It specifically directs in the statement itself, it says complete this form yourself. It doesn't say ask your real estate agent for assistance. It's complete this form yourself. It's the seller who must answer yes, no, not applicable, or unknown based on the seller's actual knowledge at the time of selling. If you should certainly recommend that your clients seek the advice of their attorney regarding filling out and exchange of the form, or if they have any questions. And that's why we've put that language into the one key exclusive right to sell agreement. Again, if you want, you can read that straight to the seller, but it's there, it's in writing. That's what fulfills your obligation. You should not be helping sellers fill out the form. Does the PCDS need to be uploaded to the MLS? No, it does not need to be uploaded to the MLS. You're not even required as the listing agent to take possession of it. Again, you just have to provide the form to the seller and let them know what their obligations are. If you're going to upload it or your seller wants to upload it, you should only do so with the seller's consent. Again, the form only needs to be provided to the buyer at the time of signing of the contract. So who has the responsibility for delivering the PCDS to the buyer or the buyer's agent? Well, it's not you. The seller is ultimately responsible for delivering the PCDS. You should recommend that the seller speak with their attorney about when delivery of the PCDS will be made. Look, I've been asked questions. Well, what if the seller wants to do it before contract? What if they want to do it at the time they had an open house? They can do whatever they want. The seller can deliver the PCDS to the buyer at any time. They could give it to anyone they want. They just have to make sure it's given to a buyer prior to delivery of a signed contract. That's all the law says. Seller, you must give it to a buyer prior to delivery of a signed contract. Can it be given earlier? Yes, it absolutely can. It's up to the seller as to when they want to deliver it. So they really should speak with their attorney if for some reason they want to deliver it sooner. You are only responsible for delivering it if you assume or accept that responsibility on the seller's behalf. So if you are going to assume that responsibility, you should make it very, very clear to the seller. And you don't even have an obligation to accept that form or have it. It's just once you provide the blank form and explain what needs to be done with it, your obligations are complete and you can have no further liability. Do you need to keep a copy of the fully signed PCDS in your file for record keeping purposes? No, there's no requirement that, again, you take possession of it. So there's certainly no requirement that you keep copies of it in your file. I will say, though, if you do accept responsibility for providing the PCDS to a buyer or a buyer's agent, then you should retain a copy of it. If you are going to be the person that transmits it to the buyer or the buyer's agent, it would be a best practice, and I think you would want to retain a copy of it for your records. So what if questions come up? And they may. I'm certain sellers will have questions about the PCDS and what to do with it. I strongly encourage you that you recommend your client seek the advice of their attorney if they have questions about filling out, if they have questions about the meaning of any of the questions, about what their obligations are under the law. The attorneys are familiar with the change in the law. Believe me, I've seen all of the emails that have gone out from different title companies, the Bar Association. I was at a Bar Association presentation last week. The attorneys certainly know that this change is happening. And they're going to have to deal with it. Again, they have to attach it to the contract. The seller's attorney, when they prepare the contract, is going to have to transmit a signed copy of the property condition disclosure statement. And the buyer's attorney is going to have their buyer sign it and attach it to the final signed contract. So the buyer's attorney is going to have to review it and review it with their client. So the attorneys are well aware of it. And I think that if your sellers have questions about it, or even if your buyers have questions about what's in there, they should speak to their attorney. All right, so what happens if the seller fails to provide the property condition disclosure statement? Being honest here, we don't know. The law doesn't say what will happen if a seller does not provide the property condition disclosure statement. And we obviously have not had that question resolved through the courts because the requirement really hasn't gone into effect yet. So it'll probably take some time to get resolved through litigation if that kind of claim is ever made. We could see the legislature amend the law, but right now the answer is unknown. So what happens if your seller asks you, should I give the form? Should I fill it out or not? You should not provide any advice with respect to that. You should never be advising sellers about whether or not they should fill out the property condition disclosure statement. Sellers who don't want to provide it should only do so under the advice of their attorney. If you start weighing in on this, you are potentially engaging in the unauthorized practice of law, violating state law, the code of ethics. You should not be giving any advice to the seller about whether or not to provide it. And you also shouldn't be giving advice to buyers about what to do if the seller won't provide it. You have to direct them to their attorney in those types of situations. Should the property condition disclosure statement take the place of a home inspection or other testing? Should buyers feel that that's sufficient? Do they then just say, you know what, I don't need an inspection. I don't need to do any other testing. I have the property condition disclosure statement. The answer is absolutely not. And where am I getting that from? I'm getting it right from the property condition disclosure statement. The statement itself says it is not a substitute for any inspections or tests, and the buyer is encouraged to obtain his or her own independent professional inspections and environmental tests, and also is encouraged to check public records pertaining to the property. What about, is it a warranty? Should buyers consider that some kind of warranty for them? Again, pretty clear answers, absolutely not. And again, this is right from the property condition disclosure statement. It reads, this disclosure statement is not a warranty of any kind by the seller or by an agent representing the seller in this transaction. So absolutely clear. And another reason why I think it's important for you to look at the form, understand it, and see what the instructions are on it. So where can you learn more? I think this pretty much covers it. I hope that you understand what your obligations are. But if you need more information, we prepared a pretty detailed legal tip about 2 weeks ago concerning the changes to the property condition disclosure statement. It's available on our website. It's at lirealtor.com/legal. And then we also have a property condition disclosure statement, FAQ, that was put together. And that's also at the website, PCDS FAQ. And we'll put these links up when we post the video. But again, it's all on our website. If you go to the legal tips, the legal tip actually has a link to the FAQ as well. And if there's any additional guidance, any additional changes that come out, we will certainly let all of you know through email. NYSAR, I'm sure, will as well. They've sent flash updates with their own FAQ, which is largely consistent with ours. So, we've provided you, I think, answers to every possible question I think you could ask. And lastly, if you still have questions, especially after March 20th, if you're unsure, please take advantage of the NYSAR legal helpline if you're a LIBOR member. It's a free benefit, and it's available Monday through Friday from 9 a.m. to 4 p.m. And the number there is 518-436-9727. So hopefully with those three things plus this webinar, you have all the information to deal with the change, which again, I think if you look at it big picture, it's really not that big a change. You're just providing a different form to sellers, and the disclosure that you have to make regarding the seller's obligations and the buyer's rights and obligations is a little bit different because they're no longer being told that they can get a $500 credit at closing. And our listing agreement will be updated to reflect that. The disclosure form that we have, the acknowledgement form that we have on Documents on Demand will be updated to reflect that. So as long as you're using those things and getting that acknowledgement from your seller, you're good to go. And it really should not be that big a change. So I hope that puts everybody at ease concerning the amendment to the law. With that, if people have questions, I'm going to take a look, and bear with me in the Q&A. We'll take a look and see what questions have popped up. All right, I see a question. Somebody had asked, well, what prompted the $500 credit to begin with? Well, that was back in 2002. I think there was concerns from, I think, even the realtor associations as well as the bar associations, who felt that it was unreasonable to ask sellers to provide this. They were concerned that sellers had to provide it. And I also think the $500, my understanding was at the time, I think the legislature felt that was really the cost of a home inspection. So they felt that if the seller wasn't going to provide this, at least they should credit the buyer with a $500 to cover the cost of a home inspection. So that's how it originated. But the legislature has now felt it necessary to eliminate that option and require that all sellers provide the property condition disclosure statement. There's a question about what is the liability on the seller after the sale is closed? Well, the liability remains the same. I mean, for fraudulent concealment, failure to disclose in that respect could still pose liability to a seller. And I guess the concern from a lot of attorneys when this law was passed was, now you're creating some kind of written record that the seller has provided the buyer. It could potentially enhance a claim that a buyer might have. That is the concern. But again, it's something now that is going to be required and not all sellers have to provide. I think we covered this. There was a question about condos, estates, and trusts and whether they are exempt. Yes, condos, co-ops, vacant land are not considered residential real property. So you would not have to provide the property condition disclosure statement in those instances. And trusts and estates, yes, are under the exemptions, but I strongly encourage you. It's really, if you have questions about whether a property is exempt beyond condos, co-ops, vacant land, new construction, that kind of thing, the seller should consult with their attorney. And I think the attorneys will pick up on this as well. They're going to really be the ones that ultimately have to collect that statement because the seller's attorney will be the one, when they transmit the contract to the buyer's attorney, they will have to include the seller's signed property condition disclosure statement. I see more questions about estates. So that's already been covered. Hang on. So somebody had asked about, and I think again, this was covered, but having a separate form that your sellers or your buyer and your buyers acknowledge that you've informed them of their obligations. And yes, that is, if you go on Documents on Demand, we have a form just for that. Really reiterates what's in paragraph 17 of the One Key Listing Agreement, almost word for word, but it's an opportunity for the seller to acknowledge that they've been informed and that you've informed them specifically of those very obligations that they have under the law. Somebody asked a question, don't need this if property is sold as is. Yes, it's required. Look, the contract of sale may say that the property is sold as is. That's what the attorney may put in there. But that's notwithstanding, the seller still has an obligation to provide the property condition disclosure statement. As long as it's residential real property as defined by the Property Condition Disclosure Act, meaning residential property 1 to 4 units, that's not a condo, not a co-op, not a vacant land, the seller has to provide this. It doesn't matter if they're advertising the property as is, it is required. So you, in all instances, should be providing the blank form to all of those sellers and letting them know what their obligations are. Another question about, do you need to keep a copy of the disclosure statement? As I said, it's not required that you do, and you're not even required to take possession of the completed disclosure statement.
Patrick, we had a couple questions about how exactly should the buyer be delivering this form to the seller, especially if they're like not in contact directly with the seller.
Well, the buyer has to, the buyer's going to get the form prior to contract. So the way it will most likely work in most instances is the seller's attorney is going to provide the form with the seller's proposed contract and give it to the buyer's attorney. And the buyer's attorney would then have to share it with the buyer, as I'm sure they would also share the proposed contract with the buyer, and review it with the buyer. There's nothing that prohibits sellers from providing it to a buyer sooner. I've had people ask me, well, can the seller provide it to all prospective buyers at open houses? If that's what the seller wants to do, they certainly can do that. And maybe that's the way the practice will ultimately develop. I think over time, it may become kind of more commonplace that that's what sellers do. But all I can tell you is what the law requires, and the law requires the seller to provide it to the buyer prior to, when they deliver that signed contract to the buyer for signature. That it has to be provided by then, but it can be provided at any time earlier. Patty asked a question, do I need to get a new exclusive right to sell for an existing listing that was listed before 3/20? No, you don't need to get a new listing agreement. If you have a listing, let's say today, you take a listing today, right? And then on 3/20, it's still not sold. I know a lot of you probably like, I'll sell it that quick anyway. The market's still so hot. But if you haven't sold it by March 20th, you don't have to get a new listing agreement. All you need to do is reach out to your seller, provide them the new property condition disclosure statement and that seller's obligations form and ask them to sign it. Just let them know that the law has changed. There's a new form, because you should have provided them the current property condition disclosure statement when you took the listing. So you need to provide them the updated form, and just get their acknowledgement that you provided it and that you explained what their obligations are now. And that's all laid out in that seller's obligations form. It's really the same language that's in the One Key exclusive listing agreement, but you do not need to get a new listing agreement signed. Let me just scroll through. I think a lot of these have been answered. Somebody asked if the form is available in other languages. It is not yet. I know we've actually asked Department of State about this because there's other forms other than the agency disclosure form. I'm not aware of other forms that Department of State has translated yet or provided in other languages. The agency disclosure form is the only one. But I will make a note, and I know NYSAR, I think, has asked this, but we will certainly reach out and ask that the forms be provided in other languages. But as of now, the form is only provided in English. All right, another question. Just bear with me too, because I got to read through these before I answer them. One must be provided. Somebody asks, you keep saying that the form must be provided to the buyer. It could be the buyer or the buyer's agent. It doesn't have to be to the buyer. But I guess the concern is this is going to lead people to believe the seller can speak directly to the buyer. I don't believe this is wise. Again, I'm not suggesting the seller speak to the buyer. The seller has to fill out this form. The form then needs to be transmitted to the buyer or the buyer's agent prior to execution of the contract. Logically, I think the way it will happen probably at first is that the seller's attorney is going to again transmit it to the buyer's attorney. The buyer's attorney is the buyer's agent. They are representing the buyer. That's probably the most logical way it will happen. But there is nothing wrong with a seller telling you that they want you to send it. You're not required to, but it can be transmitted earlier. I'm not advocating that the seller speak to the buyer, that the seller hand it directly to the buyer. I'm just telling you what the law says. There's a whole number of ways that the actual exchange can happen. But I think the way that I envision it happening will be that the seller's attorney is going to deliver it with the proposed contract of sale. And it's at that point that the buyer will have an opportunity to look at it. And the buyer, again, has to then sign off on it, and it has to be attached to the contract of sale, the fully executed contract of sale. So that's why I'm saying that the buyer's attorney most likely will be the person that will receive it and need to receive it. Let me see what else we have. Somebody asked if there's not yet a fully executed contract by March 20th. This is kind of a very specific question, but there's a question saying contracts went out a couple days ago. The buyer might be signing the contract before March 20th, but they may not. So if they sign it on March 20th or later, can the seller still take advantage of the credit and not provide the disclosure statement? I think that should be discussed with the attorney. My opinion would be no. I think there has to be a fully executed contract of sale at that point. But I would speak to the attorneys on that particular deal to find out. Again, I think the property would have to be in contract before March 20th in order for the seller to take advantage of the $500 credit. Somebody asked about the other property condition disclosure form is no longer needed now. Well, the current form, the one that's 6 pages that has the 48 questions on it, that is the form that you should be using now. So even if you take a listing on March 18th, you should be giving the seller the current form, and you have to let the seller know that they can take advantage of a $500 credit. And as silly as it may seem, then on March 20th, you would have to give the seller the new form and let them know there's a change in the law. They can no longer provide the $500 credit, but you should still be using the old form up until March 20th. We've put both forms on our documents on demand. I'm pretty sure that the new forms will also be on OneKey Instanet within the next day or so. So they'll be there for you to download, have them ready, but you should not be using any of the new forms until March 20th. We've clearly marked them on LIBOR's documents on demand, and I'm sure OneKey is going to be doing the same thing. But again, until March 20th hits, you want to make sure that you're still using the current property condition disclosure statement, the current OneKey exclusive right to sell agreement, and the current seller's obligations form. Sorry, still there's a lot of questions in here, so just give me a second. I'll try to answer as many as I can. Some of these are what if you have a listing and are still waiting for the property condition disclosure statement to be completed and there's an offer on the property? After March 20th, there can't be a contract without a completed property condition disclosure statement. If you get into mechanical issues about, again, seller doesn't want to complete it, something along those lines, those are legal issues that have to be addressed by the attorney. As much as you want to try to jump in, you are going to potentially get yourself in trouble by doing that. I said at the beginning, I think this is going to be a bit of a bigger change for the attorneys. They're going to have more questions. They're likely going to have to be involved in helping with, navigate potential answers, potential issues, objections to providing it, things of that nature. Those are legal issues, and those are not things that a real estate licensee should or can be getting themselves involved in. Somebody asked, once the form is filled out, if the agent reads it, is the agent responsible to put the conditions in the listing and disclose to buyers? I mean, certainly the agent's responsibility hasn't changed, that if they're aware of things that they're asked about, they must then disclose them. They cannot avoid disclosing anything if asked. So it would be like learning any other thing. Your obligations with respect to disclosure have not changed. There's questions in here about if the parties can waive things regarding the property condition disclosure statement in the contract. Again, those are legal questions that the parties have to speak to their attorneys about. I think most attorneys feel that the property condition disclosure statement will not be able to be waived by the parties. But that is a legal determination. That is not something that the real estate licensee can provide advice on or should be discussing. So I think it's going to be critical that when you get some of these questions that you just explain, look, this is a legal document. As much as I would like to help you, I would be going, I can get in trouble by answering these questions. And the best way for you to get the right answer is to speak to your attorney. So yeah, a couple people are asking about waiver and things of that nature. It's sellers have to speak to their attorneys. I personally don't think it's something that can be waived, but that you should not be giving any advice with respect to waiver. I'll go back again to what I said at the beginning. Provide the form and inform the seller of what their obligations are under the law. And that's written right in paragraph 17 of the One Key exclusive right to sell agreement. Once you've done that, you can't have any liability. The minute you say more, do more, you are potentially exposing yourself. So the minute you start talking about waiver, you're potentially getting yourself into trouble. So don't go down that path. Somebody has asked, what if the home inspection discovers something the homeowner isn't aware of? Do they need to change their answer on the form? It's what their knowledge is at the time that they completed the form. So I would say it's if they have their own home, like if a seller has their own home inspection pre-listing and they become aware of things, yes, they would have to disclose that on the form. But I'm presuming that most sellers will be completing this right around the time that the contract is transmitted to the buyer or before, and likely wouldn't see the buyer's inspection report. And at that point, the buyer would be aware of it as well. But certainly if a seller learns of something in an inspection report, the seller, their own inspection report, the seller would have to disclose. Yeah, it's based on the seller's, a couple questions about what does the seller know? How does the seller know? It's based on the seller's actual knowledge. Again, you should not be advising sellers on how to fill out the form. You can provide them the form. You can walk them through the language at the beginning on the top, but beyond that, you're stepping over the line if you start advising sellers on how to fill out the form. It's not something that you should be involved in. Maria, is the completed PCDS attached to the contract of sale? Yes, the final contract, the fully executed contract of sale, the completed PCDS signed by both parties must be attached to the contract of sale. How will this affect loan approval? I don't know. I don't think it should really have a material effect on loan approvals, but again, I think when you get into certain questions like this, at that point, it will be with the attorneys. It's really going to be incumbent upon sellers and buyers to speak to their attorneys. And a lot of the focus has been on the sellers, but the buyers, I think, also will need to speak to their attorneys. I think buyers' attorneys, when they receive the proposed contract with the property condition disclosure statement, they're going to have to transmit that to the buyer and potentially review it with the buyer. I mean, things that are disclosed in there may trigger some proposed changes to the contract. But all of those things are going to be, I think, in the column of the real estate attorneys. Um, there's questions about what if the seller writes unknown to everything, but then the buyer learns of things afterwards that, let's say, the seller. Yeah, look, that's why sellers need to be truthful. I think it certainly, again, you should not be giving advice on how to fill it out, but if I were an attorney advising a seller, I would not advise a seller to write unknown to everything. You have to be truthful. This is a written record now. And if proof later comes out that you misrepresented yourself, there could be potential exposure. So I think sellers obviously need to be truthful. Somebody asked, why was this not left to the attorneys to provide? You'd have to ask the state legislature. I just report the law. I don't write the law. Look, there could be changes to this down the road. I certainly the legislature may make changes once they see how this plays out. I will say upstate, my understanding is a lot, and I say like north of like Hudson Valley area, most sellers there have historically provided the property condition disclosure statement. They'd never really latched on to the idea of providing the $500 credit. And there really hasn't been a groundswell of litigation up there. It's just kind of become a commonplace thing. So maybe that's the way it develops down here. I don't have a crystal ball. I can't tell you how it will turn out. But this is the way the legislature wrote it up. And I would say it's from the real estate licensee's perspective, it's not that big a deal. It really, you may get questions, but a lot of those questions are things that you're really not equipped or capable to answer and should not be answering. I see a number of questions in here about specific situations and what needs to be disclosed. All you can do is tell the seller that they have to truthfully answer the questions based on the knowledge they have at the time. And you can't be getting into, into assisting them with it, filling it out for them. If they have questions about particular situations, they're going to have to speak to their attorney. And somebody responded, some sellers might think we as agents are not helpful regarding the disclosure. You need to explain to them my legal obligation and what the law says I can provide you is I need to explain to you, provide you this form and explain to you what your obligations are. That's all the law allows me to do. If I do more, I'm doing a disservice to you. I think that's the strongest way you can convey that message. And I think people would appreciate that. Angela, commercial properties are exempt as well. Yes, this does not apply to commercial properties. It's only residential real property as I had defined it earlier. I'll try to answer 2 or 3 more. A lot of these are repetitive. Again, I'm doing my best. There's almost, I think we're over 100 questions now. So if I can't get to all of them, I apologize. All right, there's a question here. If a buyer asks for the disclosure before making an offer, are you obligated to show it? No, the seller is not obligated to provide it until the time they're providing an executed contract. That's it. Can a seller provide it sooner? Yes. Maybe the seller says, I've got no issue. I'll provide it. Sellers may decide they want to provide it to a buyer before a home inspection. Sellers may want to provide it at an open house. They can do that. There's nothing wrong. All I'm telling you is that legally it needs to be provided prior to delivery of an executed contract. That's when the seller must provide it. They can wait to that point. If that forces a deal to fall apart, well, then that's on the seller. But so another question that I see in here, is it required before inspection or after? Inspections are relevant. The law only says it's with delivery of an executed prior to delivery of an executed contract. So that is when it has to be provided. It could be provided at any point up until that point. It's really up to the seller to decide. What are your responsibilities as a buyer's agent? I think I covered this, but it's really just letting the buyer know that they have the right, and it's on that buyer's rights and responsibilities form. But you want to let the buyer know that they have the right to receive this, and that they have to sign it once provided, and it must be attached to the fully executed contract of sale. That's the only disclosure requirement you have as to a buyer. Let's see one more. Hang on one second. Can the seller's attorney provide the document with the potential contract to the buyer's attorney? Yes. I think that, again, that's where I envision the exchange most likely happening, that the seller is going to be providing it to the buyer at that time, because it's the buyer's opportunity to review it before the buyer signs the contract. And if the buyer deems the contract acceptable, the buyer will have to sign the property condition disclosure statement on the last page, and that will then get attached to the contract of sale. Somebody asked about, do I recommend the seller do a pre-inspection for the house? I think they should talk to their attorney. I can't make a recommendation for the seller with respect to that. Question: what if the buyer does not want to make an offer until they see the form? They don't have to. The buyer, look, if that's what the buyer says, well, I'm not making an offer unless I see the form, they have that right. But the seller also has a right not to provide it. Again, the seller only has to provide it prior to execution of a contract. That's the seller's obligation. A seller can provide it sooner. A buyer can demand it sooner. But there's nothing that says a seller or buyer has to provide it. A seller has to provide it any sooner. And a buyer can certainly walk away if a seller does not want to. Somebody had asked, what if after closing, the homeowner didn't know there was an issue and didn't put it on the disclosure? Well, they can only put on the disclosure what they know. Again, it has to be based on their actual knowledge. So if something happens to the property after closing and the seller didn't know about it, well, buyer beware. I think most attorneys are still going to be putting language in the contract of sale that says the property is still being purchased as is, that the buyers completed all of their inspection and that they're fully satisfied. So that language will still always be there. I don't think that this creates absolute liability for a seller. It's really only going to create liability if a seller commits some kind of misrepresentation in making their disclosures in the form. All right, we're at an hour, so I think we're going to end. I think we answered just about all the questions. A lot of the ones in here that are left seem to be pretty repetitive. Again, please take a look at the frequently asked questions that we posted on the legal tip. And if you have further questions beyond that, please reach out to the NYSAR legal helpline. So I appreciate everybody being here. I appreciate the active questions that we received. And I hope everybody has a great rest of the day. And I don't think anybody should have any problem dealing with this change. So thank you, everybody. Take care and have a great day.